Oh, sorry. Continue. This is Max. Law clerk working for us. Nice to meet you. What case you guys here for? David Fountain for
Perfect. Plaintiffs?
Yep.
Perfect. Thank you.
No idea. So the darkness kind of towards whoever the trial is. Scary thing ever. It's like everybody turning to jurors like all this. It's like, can't talk. Can't acknowledge your existence. Yeah, which obviously. Yeah. Yeah. Yeah, that's the thing. That was like their circuit court is huge. Yeah.
For the 1:30, you're in your Crockett
Perfect.
for defendant.
Thank you.
Rise.
Thank you, Ms. Stewart. This is docket 25-3144 NI. David Fountain versus Ilya, how do you say it?
Ilya.
Ilya, all right. Barabanova in his individual and official capacity. capacity in the city of Lansing jointly and severally. Council, your appearances.
Nancy's not here.
Oh, you know what, where is she?
Right here.
Oh, okay, so sorry, okay. Okay, it's okay, it's always good. I think Nancy and, Nicole are busy doing other things, so I didn't see her either, so, and you know, once in a while I've done that, so we're good. All right, council, your appearances for the record.
Good afternoon, Your Honor. Michael Sprague on behalf of plaintiff David Fountain.
Good afternoon, Your Honor. Thomas Bendon on behalf of the defendants.
Good afternoon, Your Honor. Lisa Hagan-Lawrence on behalf of the defendants.
Thank you, and this is, defendant's motion for sanctions, is that correct?
Yep, we have two motions up this evening.
And then there's a motion to compel, correct?
Yeah,
Yeah.
and that's both discovery motions.
All right, thank you. You may be seated, you may proceed with your motion at the podium, please.
Good afternoon, Your Honor. As mentioned, Thomas Bendon appearing on behalf of the defendants. We have two motions set for hearing this afternoon. If this court has a preference as far as how they're.
It's up to you.
Okay, perfect. I would like to begin with the expert motion. This is defendant's motion to strike and or compel the deposition of plaintiff's retained accident reconstructionist, Tim Robbins. To give you a little background, very briefly, this is a motor vehicle accident case. It's a January 2025 accident, two-car collision. Police officer was driving with lights and sirens. Plaintiff was driving a vehicle as well. They struck in an intersection. Since the case was filed, we have conducted pretty extensive discovery, written discovery, disclosures, depositions, what have you. And in late 2025, plaintiff initially identified Mr. Robbins as an expert witness in this case, in the area of accident reconstruction, which obviously is a pretty significant issue in the case. It's the liability issue that's on the table. At that time, defendants sent written discovery. We also noticed the deposition of Mr. Robbins, a Dukas Tatum deposition, also asking for the traditional expert items, reports, what he reviewed, notes, so on and so forth. Of course, plaintiff also had the obligation under disclosures to provide that as well. Over the following 5 months, we received nothing regarding Mr. Robbins, not analysis, not reports, not any of those things. What we received instead were issues about scheduling, generic statements about, hey, he had been retained, he's going to testify about the incident. Obviously, that doesn't do much for us to tell us what he's going to testify to. Ultimately, the deposition did go forward at the end of April. Right before that, so again, about 5 months after our initial request, we get a batch of items about Mr. Robbins' review. Within that, he had some notes, he had some records. Notably absent from that, first and foremost, any final opinions on the case, any reports, anything like that. And then secondly, key pieces of the record that had not been reviewed as part of that process. And this, at that point, the theme really carried over into the deposition as well, which was a week later with Mr. Robbins. He was asked repeatedly about what are your opinions on this case? What are your opinions about the incident? So on and so forth. And what we got is, my review is still ongoing. I haven't completed it. I'm still reviewing items, including some of the most notable ones that were absent from his review. The defendant officer's deposition transcript, he had not reviewed that, as well as key components of the video. Now, in most car accident cases, we don't have video, but we have a police vehicle involved in this one. So we have body camera, dash camera that captured the incident. So highly, highly probative of the issues in the case. And he had not completed that review. He also clarified in that deposition that the production before had actually been incorrect, that it had been updated and he had new records to produce. So the batch of records that we had finally received after 5 months really wasn't the correct.
So the he you're referring to is the plaintiff.
Mr. Robbins, the expert.
The expert, but plaintiff's witness.
Correct. They're retained expert witness here.
So when that was this April.
End of April, yes. So about 5 months after we initiated these requests. Now, plaintiff has framed this Mr. Robbins' testimony as sort of the boilerplate expert lingo of, well, yes, if something shocking comes out at trial, I'll review my opinion. Or if some new video shows up, I'll review my opinion. That's not what this is. If that was what it was, we wouldn't be here today with this motion. And I would direct this court, page 75 of Mr. Robbins' deposition, it's exhibit 3 to our motion. I asked the question, so I guess, have you completed your analysis or is it still ongoing? Answer, well, I haven't seen the officer's deposition yet, so I'd say it's still ongoing. I don't have the fullness of the case file video, so I mean, it's still going to be ongoing. I haven't seen any work from any other experts. There may have additional data that I don't have that hasn't been, either disclosed or provided. I'll look at that. So I would say it's still ongoing at this point. I then followed up with a few other questions on page 76 about essentially, could all of your opinions change? And his answer was yes, in the affirmative, that his opinions could change when he reviews all of these. This is not if something shocking comes out, I will change my opinion. This is, I haven't completed the review. I haven't looked at it. And I will note that, again, the deposition transcript is a key piece, but the other piece were his statements about the video. He had multiple admissions in there that were not consistent with the record because it's apparent he did not review all the video.
What's the name of this expert?
Mr. Tim Robbins.
Okay, because I have, under exhibit 3, I have, this one found.
Okay, perhaps I'm happy to walk up the transcript if you would like.
Okay, yeah, you read it, it's fine. I think I pressed somehow, what is being put together. It's just human error. I got 2 of the same in one.
Okay.
This is not a big deal. Okay.
I apologize if that's the case, but the moral of the story here on this is that as we stand here today in mid-July, we still don't know what Mr. Robbins is going to testify to.
Tell me, when does discovery end?
So discovery has closed at this point.
When?
I think at the end of May, I believe, around Labor Day is when we filed the motion. Unfortunately, due to scheduling things, we didn't get here before today. Okay. What we are asking for from the court is really one of 2 things. One, order Mr. Robbins to come back, be prepared, review the record so he can give his opinions at that point. We have a right to him. We should be able to examine him and get those opinions. Otherwise, he should be stricken from the record. And I would direct this court, page 6 and 7 of our motion go over the Dean factors as far as sanctions and when they're justified and striking an expert witness. I would say 7 of the 8 are blatantly satisfied in this situation. The first 7, referring to whether the violation was willful, the history, the prejudice, the notice, the delay, things of that nature. We're talking at this point basically an 8-month prolonged battle for this. We just want to know what he's going to say at trial and his opinions on this. The only one that I would say is probably not met today is factor 8, whether a lesser sanction would serve the interests of justice, which we would posit to the court would be just having him come back and doing the deposition so we can find out, what his opinions are on this case. And I think to sum things up most clearly on this issue, Your Honor, I would just posit the following. So defendants are currently preparing our motion for summary disposition, which goes to the liability, which goes to the governmental immunity issues in this case. What are the odds that plaintiff's response is going to refer to Mr. Robbins and or include items that are not produced?
I got it.
Yeah, I would say about 100%. So at this point, we would ask for those. If Your Honor has any further questions, happy to address those.
No, thank you.
Thank you.
Well, I do have one other question. Is this the only piece of discovery that you're concerned about? And obviously, if they do allow him to come back, there would need to be an extension because perhaps you might need some further discovery based on what he concludes.
I think that would be appropriate. My expectation, though, is probably that I don't think I would need much other than his depth. We do have the cell phone motion, the second one, but other than that. No.
Okay, thank you.
Thank you, Your Honor.
Response?
Thank you, Your Honor. Just wanted to draw some attention here. I believe that some of the characterizations are just simply untrue there. In terms of pieces of the video that were missing, our office turned over to Mr. Robbins everything that we had received from the defendant, who initially was in possession of these body cam and dash cam videos, and to the extent that his opinions may be indicate, or as defense counsel believes, indicative of not a complete record. I disagree with that characterization. I think a simple cure for that would be cross-examination.
Well, it'd be an evidentiary hearing first, because we're not gonna go to trial with half a case or half a witness statement. So we can have an evidentiary hearing on who's telling the court the truth or not, but the bottom line is, that I'm concerned about is, does your expert have all of the information first? Second, did he reach a conclusion? If he didn't reach a conclusion, why is he here?
Your Honor, he did. He expressed several opinions on the case. He did not provide an expert report because the court rules don't mandate that. And if Your Honor mandates that we put his opinions in the form of a report, that would be the order of the court. This is not, sure as Your Honor knows, federal court does require such a written
We're not
report.
federal court, we do a lot of things differently, but let me just say that there was a deposition. Apparently, you tell me if it's mischaracterized, you're all in front of me because you don't agree. So let me hear your version. Did they ask questions about, have you been able to review these things? Have you reached a conclusion? What is that conclusion? Was he able to answer those things, or was the answer, I don't know, I still haven't reviewed things? Because that's not acceptable.
I believe, and
I don't like to, as I always say, take your beliefs to church, got evidence. I want the evidence, I want the facts. I don't care what anybody thinks or believes. What do you got?
Your Honor, I think anything that would be allegedly missing, he did concede, as I've heard experts say in countless cases, that if presented with new information, his opinion might change. But he did give an opinion about how fast the
What was that
officer was,
opinion?
that the officer was going too fast and the officer was not abiding by the training rules and policies that are expected of operators of emergency vehicles. And that was a proximate cause of the accident. And the accident could have been prevented had the officer exercised due care and caution while operating his vehicle at a high rate of speed. He was very clear.
Stop right there. Counsel, is that what was conveyed, and were you able to cross on that during the deposition?
Your Honor, all the opinions that were offered by Mr. Robbins were prefaced with he hadn't reviewed the entire record. And I would note page 76 of the dep. Okay, so it's fair to say your analysis on these things might still change. Possibly, yeah, yet.
But is he referring to what you talked about earlier, that things come out at trial, which I was a trial lawyer for 20 years before I took the bench. We all know there are surprises at trial. There's no perfect witness, right? We can all agree on that. Okay, and we all have to deal with that. But that's different? Is he referring to, if new evidence comes out that I'm not aware of, I have to factor that in and that might change my answer? Or is he referring to, I haven't been provided with everything?
The latter. This is directly follow up to what I read earlier about how he had not reviewed the death transcript and that I don't have the fullness of the case file with you. That's his quote.
All right, so are you disputing that?
Your Honor, I feel like that is taken out of context. He did give bold opinions, and this was under.
Do you have the transcript, sir? Counsel, please approach with the transcript. You're going to go off the record, counsel. Now I don't want to see it. Show him. As a reminder.
Yeah, could I just complete what I believe like one of these portions is to think get
Let's
better.
go back on the record. Tell me.
Okay, so he did mention things that I haven't seen the officer's deposition yet.
Slow down.
There may have been additional data that I don't have that hasn't been, either disclosed or provided. I'll look into that, so I would say it's still ongoing. So it's fair to say your analysis might still change, possibly, yeah. But Your Honor, I think I feel like that was just a small snippet of the overall deposition transcript, and
I don't know, I wasn't there, so here's what we're gonna do. This is just a silly fight, and I feel like both of you could have and should have reached a decision on this, probably anticipating what the court's gonna do. I'm going to order that we have a subsequent deposition where those loose ends are followed up on. Now, if your second part of this is, if your expert says, I did mean that I reviewed everything, and I really did mean that if there's something new at trial, my opinion might change, he can send us an affidavit, or you can send us an affidavit as to that. Sir, if you still want to cross him on that during the dep, we'll still hold one. But I think we need some clarification as to what he reviewed. Was it complete? Does his opinion any opinions that you all asked him, were they based on the evidence that we know is coming in on trial, so he has a full review? And if not, he needs to fully review all of that and then give us a conclusion. Okay, if there's still a dispute, please set an evidentiary hearing in front of me and I will determine whether or not he'll remain an expert.
Thank you, Your Honor. May I make one statement
Sure.
for the record? So I do want to mention the two things that our expert did say that he didn't have that might change is first and foremost, a deposition of the defendant officer who was operating the vehicle. That deposition, our office did not have the transcript.
But then you move the deposition. Doing half a deposition means you have to do the other half later, and that's essentially what counsel's asking for. So, because isn't that important information?
Your Honor, I do think it is, but I mean, I do. My second part is.
Counsel, you're a learned counsel. It is. I mean, it may or may not change the expert opinion, but he needs to factor that in, saying if all of these factors are true, then this is my opinion. If they're not, it's subject to change. Right?
Correct, Your Honor. But I would like clarification as to, so we're happy to arrange dates again. I just don't think, based on the motion, that plaintiff should bear the cost of producing the expert for a discovery deposition when the two pieces of evidence that we did not have were the officer's deposition transcript and in a separately filed motion to compel. We had been seeking the officer's deposition since September of last year.
Slow down, sir. Please. I can't even write down, and I want to make sure that the court reporter gets everything. It's going to sound like one long word. She's going to have to listen to it 10 times. So I'm sorry, what's the other piece you don't have?
The defendant officer's deposition transcript, which I think in
Okay.
for all intents and purposes, oh, I'm sorry.
What's the other one?
The experts file, the opposing defense expert file, and to date, we have not received any new information to forward to our expert on that front.
Did he have that, counsel?
Our officer had not, or not our officer, excuse me, our expert had not completed his review because he's a rebuttal expert who's going to be responding to Mr. Robbins. We are more than happy to disclose that to plaintiff's side once he's prepared that. We were waiting for today's hearing, but we are more than happy to work with Mr. Robbins and plaintiff's counsel for a date that works where he can be ready and have fully reviewed the file.
And what about the deposition of the officer? Did he have that?
That was completed prior to the deposition, yes, sir.
How is it you didn't have that, sir?
It was a couple days before. We did not have the transcript.
Did you request it?
We have the transcript currently.
Did you request it before the deposition? You didn't have it?
We requested it at the deposition, a copy as soon as it was available.
But you didn't have it before the deposition. You didn't request it until the day of the deposition. Is that what I'm hearing?
No, we requested the deposition from virtually immediately at the time the testimony was taken from the officer.
Okay, and it was provided before the deposition?
I think plaintiff's counsel is correct as far as the timing of when the transcript was received. My understanding, though, is that there was no express request placed on the deposition transcript. We also never received. I don't know when he receives his copy of the transcript, Your Honor. I can say our office did not receive the transcript until after, but I know there's real time. You can order a draft. You can order those kinds of things. I'm not aware of any of those efforts, but more importantly, if they had reached out and said, our expert has not completed his review, can we move it back a couple of weeks? We would have gladly complied with that.
Okay, at this point, plaintiff's going to bear the cost, but I'm going to reserve my decision until this case moves forward, and then what we may very well do is split it, or I can shift it over, but it does appear that this was done without having all the pieces and should not have gone forward. If you didn't have it, you move it. So he's going to do a follow-up deposition limited to the issues at hand about the opinions, and all information will be turned over to him. If it is not, whoever does not do it will be sanctioned and possibly pay for this.
Thank you, Your Honor. Is there a time duration limitation to this? I just want to make clear what.
What's the trial date? Do we have a trial date?
The trial was recently adjourned. We don't have a date as we sit here today.
Okay. How much time do you need to, I don't know, how busy is this expert?
Well, Your Honor, we did have a new development too.
What is that?
The council roughly 2 weeks ago informed me that the defense patrol officer's vehicle was available for inspection. I was not aware of that until recently. We just this morning provided dates. So my concern here is that the scope of the deposition might exceed what.
Okay, so that and any new issues, that would be a new issue. I just don't want a deposition that goes through and regurgitates what you already have. Because that will cost double.
Correct, Your Honor. But to the extent, could we put in the order that any
And all new issues.
and that
Follow-up questions to what had been done prior that wasn't fully explored. How's that?
and plaintiff, and just understand your order is that plaintiff initially bears the cost, but the issue can be
Initially, but
revisited.
it's preserved if we're shifting later. So, and we can have an evidentiary further hearing on that, and I'll make a further decision, but right now, plaintiff is going to bear the cost, and then this discovery now is going to be open until November 2nd. Actually, I'll do November, it's a Friday, let's do November 6th, that's a Friday, at 5 p.m. And you've got time for your experts, you can review the vehicle, and you can do any additional experts, trade all information, make sure that all information is exchanged before any further depositions are done or continued. Anything else?
That's it. Thank you.
Next motion.
Thank you, Your Honor. So our second motion has to do with plaintiff's cell phone. Again, I would say a relatively similar timeline. I know we've laid it out in our brief towards the end. There's kind of a bullet point list there as far as some of the dates. We have, since October of last year, we have been seeking information related to Mr. Fountain, plaintiff's cell phone. We have sent written discovery requests. We asked for it related to his deposition. We also sent a request for forensic inspection later on. And the biggest thing that I would note to the court as far as the timeline is concerned is we asked for these things leading up until around Christmas time of last year. We didn't get anything. Mr. Fountain then appeared for his deposition. I questioned him extensively on his cell phone use, his social media use, what he had, when he had it, and importantly, was he using it at the time of the accident? And he admitted he had it on his person. He admitted he had a setup inside of his car where he could presumably Apple CarPlay, something like that. He also explicitly acknowledged having numerous messages about, I think some of them had pictures of the accident in there. They were discussing what happened and then his medical recovery in the months thereafter, which obviously goes to his damages in this case. There was an agreement during the deposition that those would be produced. We didn't get anything in the weeks thereafter. Then in early March, I deposed, I guess a friend, a romantic partner, I'll say, and then his brother. And both of them produced messages that they had with Mr. Fountain about the accident, about the recovery, about these kind of things. At that point is when we sent the request for the forensic inspection, because obviously Mr. Fountain testified he didn't delete things off his phone. He had the same phone that he had back when the accident happened, but we were getting something from them and not from plaintiff. At that point, I got a complete objection to any forensic inspection, any review on that point. I did get some messages that were produced from plaintiff at that point, but I would note for the court that what we are looking for with regard to Mr. Fountain's cell phone it's really twofold. One, we have the messages thing, which if Mr. Fountain is willing to do an affidavit or something to that effect that he's turned over all that messages, that would satisfy defendants on that prong. The second prong, though, has to do with GPS, metadata, those kind of things regarding the exact time frame around the accident. I have spoken with plaintiff's counsel about this issue. We have proposed, hey, we're open to scope discussions, we're open to search terms, we're open to these kind of things. I don't need everything on his phone since he's had it. Frankly, I don't want to look through that stuff. What we're looking for is evidence that would go to what he's doing at the time of impact. And I've clarified in the record, Mr. Robbins, who testified about the fact that we don't have any conclusive evidence. The video does not pick up where Mr. Fountain's head is pointed at the time of the accident, whether it's looking down or looking sideways or what have you. So that's what we're looking for at this time. And what I would ask the court is either plaintiff be compelled to have a forensic inspection and or supplement with those items, or that a spoliation instruction be entered regarding those, because it is clearly prejudicial to the defense, whether, if he was on his cell phone, that would have a clear impact on the liability assessment of what happened here back in January of 2025.
But you also want any accident photos that were taken at the time too, not just.
Absolutely.
So,
If they have items that, I'm not looking for everything under the sun, just those items.
Response was the problem.
Your Honor, prior to filing this motion, Mr. Fountain went through his phone. We provided all these conversations that he had in a group chat with regarding his health. They have that, and at the end of the day, this motion is purely conjecture. Now, Mr. Fountain was presented for a deposition, was cross-examined. He was asked, what were you doing on the date of the incident? There's no dispute that he had a green light. You can clearly see the car very slowly approaching into the intersection. No indication, as can be plainly seen on the video, that he was doing anything wrong. He had a green light and he was in the intersection when the accident happened. The officer, it's undisputed, had a red signal and proceeded through. Obviously, we disagree about liability, but I think those facts are very, very clear. We've provided everything that they've asked for in terms of these conversations that they've had. Mr. Fountain testified he was going very close to his home. He was picking his daughter up from school. It's very close. He is used to the route. He had no GPS running. He was not on his phone. It was a route he's familiar with. His car was equipped with an infotainment system, so he would have he testified very clearly he was not on his phone. And I would like to point out, there's no case law that says that Mr. Plaintiff and Mr. Fountain's position should hand his cell phone over. I think that's intrusive for anything more than just conjecture that he may have been on his phone. There's no indication of that. He had a green light. We can see what his car was doing in the immediate moments up to impact. I think this is just your clear definition of a fishing expedition.
What about the accident photos? Have those been turned over?
Everything that we have has been turned over.
And I think they're asking for the metadata or whatever you want to call it, and the forensic examination of locators that we don't know, but cell towers know, because they can tell exactly where he is and what's pinging, whether he's on or not, and his geolocation or whatever. And I think your cell phone gives a lot of information that none of us know. And so when you get those, that information, it can only be gotten from Verizon or what have you. I sign those warrants all the time for law enforcement because they're looking for exact locators, and it's very helpful in crimes. This isn't a crime, it's an accident, but I think that's what they're really looking for. So other things that you cannot provide, but the data that comes directly from a cell phone. And look, it sounds like if your client's turned all that over, it's probably in his favor anyway. He's said, here's where I am, and that's what it's going to show, here's where I am. But I think there's other information that could be compelling one way or the other that they would like to see. You don't agree with that?
Your Honor, if that's
why ruling no comply, I get that, but is there a reason you don't want to comply with that, or is there an argument against that rationale?
Your Honor, if there is an order, I would like it limited to exclude any messages. I just think there's private and personal information that's far beyond the scope.
They're only interested in the accident messages and pictures and the locators for that time period. It could be a very narrow order or warrant or subpoena or whatever it is you guys want to do. I would agree, and I think he's asking for a narrow construction because none of you have the time to go through everybody's. If you went through my phone, you'd be retired by the time you went through all the crap that's on my phone. I'm trying to delete it daily. I mean, nobody wants to go through everybody's junk. So they want a very narrow limitation on it as well, only what's relevant to this case. So if you all want to craft it or talk about it now, come up with an agreement placed on the record, that's fine. But as I understand it, that's all you want is what's limited to that those few minutes and the pictures thereafter, correct?
Correct, Your Honor, just very directly, narrowly to.
Can you two go in the back and talk about it or craft something? And then if you disagree, I will be the tiebreaker.
Happy to have a conversation, Your Honor.
Great.
Happy to do that as well.
Okay, now, is there anything else I need to order today or hear about?
I don't believe so. The only point of clarification I would ask is this court said discovery is going to be open to November 6th, I believe earlier.
At 5
Is that just for the issues that are brought up here and things?
Well,
that
it's for the
flagged out?
issues, it's for the issues brought up here, and then anything that stems from those, I can't limit that, because if something new comes about from either one of you, say, oh my gosh, I didn't know this, or my client didn't know that this was important to me, or they said something and now we need a different expert or a second expert, or he finds out his expert doesn't have the answer he wants, he might want to get a second expert.
Perfect.
You know, you're smart attorneys, don't waste my time. I'm not opening up everything that you've already done, but I think it's based on what we are opening up, if there's new information, go for it. Because the only thing that I'm gonna do is, you're gonna waste my time, and the answer's going to be, I'm extending discovery again. I don't wanna do that. Let's use our common sense on all fronts, okay? And if you have a problem, you certainly can, through my law clerk or judicial assistant, set up a conference call with me so we don't have to do this, and I can quickly resolve the issue. And then if we can't resolve it, we'll just make a record of it, or we'll make a record of it later when we come for something else. I like one-stop shopping, and common sense needs to be in all these cases, so y'all make your money instead of spending it on your time. You know, we could spend it on other cases, but, you know, not waste the cost on this.
Understood, Your Honor.
Understood, thank you.
Thank you so much.
So who's preparing the order, and then if you can't agree, you're gonna let me know. So if you agree today, want to put it on the record, let me know. If you agree, don't want to put it on the record, unless there's a disagreement, let me know that too. Does that make sense?
Yes.
Yes, yes,
Can
thank
prepare
you.
the order?
Yes, we'll prepare.
Great. Okay, thank you.
Thank you.
I'll for this record unless they want to put something. Next matter. This is docket 252811 CK Alexander Crockett and Hillary Crockett versus Lynn Smith Insurance Agency Inc. doing business as Maurice Agency. Counsel, if you are here for the record.
Good afternoon, Your Honor. Elizabeth King, appearing on behalf of the Crockett's.
Randall Phillips on behalf of the defendants.
And yes, this is defendant's request motion.
This is defendant's motions. We have two motions pending. We were just able to resolve one of the two motions.
Okay.
That's the motion to compel, and I
Great.
could set forth what our agreement is, and then I have the other motion is to amend our witness list or to provide a supplemental witness list.
All right, is there an objection to that?
No, Your Honor.
Then you've agreed. Prepare the order. Great.
No, on the witness list, we do disagree, I think.
Oh, why?
Misunderstood.
I'm sorry, I did misunderstand. So there is a disagreement on the amending the witness list?
Yes, Your Honor.
Okay, you may proceed on that then.
Your Honor, with respect to the motion to compel, you agreed to, was a request for phone records and for records regarding a prior water loss. The plaintiff has agreed to provide the records regarding the prior water loss, and they've agreed to provide authorizations for phone records for a more limited period of 2013 and 2018 to 2020, and plaintiff's counsel will be given the opportunity to review the records, to redact any irrelevant or personal information from those records.
All right, sounds
Okay,
good.
the second part, the second motion has to do with a request to amend or supplement our witness list. This is an errors and omissions case against the plaintiff's insurance agency, and it relates to a fire loss that occurred in 2023 in September, and there was a complete loss at that time. Prior to that, there was a water loss that occurred, which substantially damaged the property which was not repaired by the plaintiffs. This court received an unsolicited letter from the neighbors, the subdivision of the home. And that letter indicated a few things which we believe are relevant and which require us to list some of those people as potential witnesses. First, it indicates that the home was condemned and vacant prior to the fire, which is certainly relevant to the condition of the home prior to the fire and damages as to what was caused by the fire versus what may have been caused pre-fire by the water loss. They also indicate that there had been a number of assurances by the plaintiffs which turned out to be false assurances with respect to what the plaintiffs would do, because there was issues about safety and the condition of the property, which goes to the plaintiff's credibility. Third, they indicate that the township had agreed to demolish the home because it was a eyesore safety problem, but that the plaintiffs were objecting or not authorizing the township to do that. So I think that goes to the plaintiff's credibility, mental state, but it also may go to the damages issue in the sense that if the township was willing to demolish it, that could affect the amount that the plaintiff might have been responsible for in terms of any demolition and repair of the home. So for those reasons, we requested that we be allowed to add the persons who wrote the letter to the court and the other members of the subdivision which were copied, or apparently the letter was written on their behalf, and plaintiff has objected to that.
Well, the question I have on this is, during this, there were a couple of different incidents. Did the insurance remain throughout this time period?
Yes, the plaintiff made a claim for the prior water loss before the fire,
Okay.
actually adjusted the claim and paid the plaintiff, but did not repair the home. So they got the money, but didn't do any repairs to repair the water loss.
And then it was still insured,
It was still insured at the time of the fire,
but it was unoccupied.
but apparently unoccupied.
Doesn't that negate, well, let me ask you, does that negate the policy? Or is that an evidentiary question, or will that be brought before the?
Well, we don't represent the insurance company, we represent the agency. And potentially there might have been an argument for the insurance company to make, but they did not make that. They did adjust the fire loss and paid the policy limit. And this case has to do with whether the agent provided sufficient limits for the policy.
Okay, great. Thank you.
Okay, thank you.
You're opposing this? Why?
Your Honor, the defendant is seeking to add witnesses who are affiliated with the township and then also these neighbors. We have agreed to allow defendant to add the witnesses related to the township. We don't have a problem with that. It's the neighbors in particular that we believe have no relevant testimony to add. They are essentially disgruntled neighbors who were chatting on Facebook about how they're upset that the home is still in a partially damaged state in the neighborhood.
So they're complaining about a significant structure damage. And don't they go to the credibility of the condition of home and what did or didn't happen to it?
I don't believe so, Your Honor. First of
Why
all,
not?
because
They're eyewitnesses, aren't they?
I'm not aware that they are eyewitnesses.
That's what discovery is about. I'm going to allow you to add them if you want to depose them and then tell me they're not relevant, then that's what we'll do. But here's the thing, is they sent to the court out of frustration apparently, which we sent to you, pictures of this. And so the only one who can testify to this would be the people who took it, how they're upset and why. And maybe they're the ones that are not credible, I don't know. But I'm going to allow them to be added and you will do your discovery and then you can rebring this. But I don't want to hear at trial, oh, well, we shoulda, coulda, woulda, from either of you. Do your discovery and then I remain here.
Okay, thank you, Your Honor. I will just say
Your
that
Honor.
we are outside of discovery.
Well,
so-
we're gonna, when's the trial date?
I'm not sure about that.
I believe we just got a notice for January.
Great, discovery is gonna end November 6th at 5.
Thank you.
And that gives you both time, and then if we need to push back the trial, or whatever, that also gives you time to hopefully get into, unless you want me to do it October, I don't know how quickly you can do this. What about case of valor mediation, have you gone to any of that?
We have a facilitation scheduled for September 17th with Judge Connors.
Okay, can you do your discovery finish before that instead of November?
Yes. I
Okay,
think
then
so.
let's just make, let's just have this end, September 4th at 5, hopefully it's before then, that gives you a couple weeks before you see.
Yes, and we have a motion for partial summary disposition also scheduled. I believe that's in October sometime.
Okay,
Okay,
we'll refer those dates, if you need to
Thank you.
change any, let my judicial assistant know.
Thank you.
thank you, Your Honor.
And who's preparing the order? Sir, you'll prepare the order?
Yes, I'll
Thank you,
prepare
sir.
the order. Thank you.
Great. This is docket 26-2068-0, Claire Gangware versus City of East Lansing. Counsel, your appearance for the record.
Richard Smith on behalf of the City of East Lansing.
Theodore Larkin on behalf of plaintiff Claire Gangware, Your Honor.
All right, and this is a motion to withdraw as counsel for the City
Yes,
of
it
East
is.
Lansing.
It is,
Alright.
yes.
You may make your motion.
Great. Thanks, Judge. This is a case in which plaintiff fell as a result of a defective access plate on a city sidewalk. Plaintiff, in the process of developing the case, filed a defect with the Department of Water and Light for the City of Lansing. The case got tendered to its insurance company, who then retained me. This all happened back in 2025. We monitored the court docket and saw that the complaint had been filed, but only against East Lansing. Me not knowing whether or not that we were going to be assigned to the case on behalf of East Lansing as well, given maybe an indemnity agreement or such, we filed an appearance. Turns out that was an error. A new attorney has appeared on behalf of East Lansing, has filed an answer to the complaint. And as a result of all that, I now seek to withdraw from the case.
Yeah, that just would be a substitution that could have been filed. So.
I tried that. I did try that. The attorneys would not agree. Plaintiffs, actually, counsel would not agree to it. So that was the reason.
Well,
for the
are they
motion.
here? They're not even here. Are they here?
Yes, Mr. Larkin is here.
Yeah, I'm here, Your Honor.
I'm sorry, why didn't you agree?
Well, I just want to clarify a few things. So, first of all, Your Honor, when Mr. Smith answered the complaint, he and I had a few conversations, and it was my understanding that he had filed on behalf, he had never represented the City of East Lansing, and had only represented the Board of Water and Light, and only knew that a complaint was filed because he was monitoring the court docket. Now, nobody from the City of East Lansing or who actually represented the City of East Lansing ever reached out to my office at all. They filed an answer to the complaint that was more than a week late. And when I spoke with Mr. Smith about that, the timeline it appeared is that nobody from the City of East Lansing had spoken with Mr. Smith, at least according to Mr. Smith's motion, until more than a week after the due date for an answer to the complaint. Now, normally I wouldn't, take this issue up, albeit, Your Honor, as you know, this is a case that's being pled under an exception to governmental immunity. public corporations are always want to dismiss cases brought under exceptions to governmental immunity on the slightest technicalities, and I feel like they should be held to the same standard. We have an answer here that was more than a week late. Secondly, when I reached out to the actual attorney for the city of East Lansing on multiple occasions and asked for an explanation as to why no one had reached out to my office to request an extension, which I probably would have granted, he declined to ever answer me. I believe eventually when I brought Mr. Smith in, he finally answered me and just said service wasn't proper. That's incorrect. I served personally, or had Ford's Legal serve personally the city clerk, Emily Gordon, for the city of East Lansing. So, because nobody from Rosati Schultz, which is the firm, the actual firm for the city of East Lansing, will give me an answer as to what their basis was for not answering the complaint anywhere near the due date. I thought maybe they would answer today, although it doesn't appear like he's shown up here either.
Okay, well, there's no reason to keep counsel on the case, is there?
No, Your Honor, I just wanted to flesh out, and I thought Mr. Smith could speak to this, but flesh out the timeline, because I think I have a duty to my clients to probe whether or not the city of East Lansing should have its untimely answer stricken and placed into default. But no, I have no real reason to keep Mr. Smith here other than to develop that chronology.
Okay, well, and perhaps he will be named as a witness. I don't know, but Mr. Smith, you're no longer, thank you for your work on this, but you are no longer on this case.
That did not come through clearly. Are you saying that I am formally withdrawn from the case?
You are no longer on this case, and perhaps they'll call you as a witness. I don't know, but it probably is worthwhile to have a conversation with them to talk about timeline or whatever. So you don't have to come testify, or maybe they'll depose you. I don't know how all these pieces fit together, but I'm sure I'll learn over time. So anything else I can help you with? And are you telling me, counsel, we need more time to answer complaint or anything else?
The complaint's already been answered.
Okay, so everything's except for you getting out of the case, everything is going as it should. Is that what I'm hearing?
It appears that way, yes.
Yes, Your Honor. Yeah, we would concur with that. We've served initial disclosures, discovery, all that stuff.
All right, I'm here, if you need me, if you just send me an order, you are removed. Thank you.
Thank you, Judge. Thanks all.
Thanks, Your Honor.
The next one is a motion for default of 2, so I probably needs to wait. I don't even see any. Well, somebody's on that. Zoom.
Thanks, try this. Okay. And this is now this. I need a. This is like as of 13th, this is 14th.
Yeah. This is the training on Zoom. I was looking at the way out.
Wait. Is this the? So council, this was scheduled for what, 2 o'clock?
Your Honor, I apologize. Are you talking directly to me?
Yeah, was this scheduled for 2 o'clock?
Yes, it was. If you'd like me to wait till 2:15, that's fine.
Yeah, I think we have tried to default and you're requesting quite a bit of money, so what we're gonna just wait for 15 minutes and then you'll probably be on your way. I don't see anybody here. My courtroom's empty except for my students who always watch, and there's nobody in the hallway and all of that, so we've checked, and so I just need to wait till 1/4 after. You got about 7 minutes.
Thank you, Your Honor. Thank you.
Mhm.
You still have it up there.
All right, this is, we're back on the record on docket 25-3144 Council,
Thank you, Your Honor. We met in the back. We have agreed on basically everything. We have one little thing that we
Okay.
haven't been able to resolve,
Okay.
Specific to photos that are on the phone.
yes.
What we have, the defense, what we have proposed is that any, and plaintiff has agreed, any pre-accident, so everything before January 13, 2025, to the extent it's not produced, it'll be stricken. So we're in agreement on that. It's January 13, 2025 through present. We have asked for, we would like the forensic inspector to go through and open up, whether it's the gallery app, Google Photos, whatever Mr. Fountain has on his phone, and just go through that date through present and see if there are any accident scene photos, the aftermath injury photos, or things specific to Mr. Fountain's medical recovery from the accident. And I will note, just as far as why, Mr. Fountain testified pretty extensively regarding how he cannot do a lot of things since the accident. And defendant's position is it is inconsistent with what is portrayed in the medical records. For example, Mr. Fountain has testified to the effect that he doesn't get to do hiking anymore like he did before. He doesn't get to ride jet skis like he did before. There are medical records suggesting that he went on a 4-mile hike just a few months after this accident. So that's what we're looking for. My understanding of plaintiff's counsel is that they object to any of that review of the app. They don't want the forensic inspector to go into the application at all.
Why is that, sir?
Your Honor, I think it's like wildly, or I think it's wildly overly broad. So basically what they're asking for is just hand over and I know it's unpublished, but I did cite a case that I think is very much on point, Craig v. Becker, that basically this type of relief to just hand over your cell phone and go through all his private photos. And I know defense counsel.
It's not all, it's limited to him. So if he's sitting there on the couch with his grandchildren or whatever it is, got his dog, that's not going to be there. They're looking for very specific, it's very narrow. It's him doing any activities that are contrary or perhaps consistent with the medical records. Point in fact, I have had people in here complaining about an accident or malpractice or what have you, saying they can't lift more than 5 pounds. And yet they are followed by a private investigator and they are found to be lifting 25-pound bag of kitty litter or dog food. And they're filmed in the grocery store doing that. So it does become relevant as to the credibility and what they can or cannot do. So we can limit it, and if you want, I certainly can look at the pictures and toss any I think are not relevant. If you're worried about that, but it is relevant as to the injuries that he's claimed. And it goes both ways. So if it shows him hiking, but then the next photo shows him sitting down because he can't make it up a steep hill, that goes in your favor. If he's hiking up steep hills, it goes in their favor. And it goes to the credibility, and it is relevant as to what's being claimed. So I don't care if you want me to do a review of those photos after they're extrapolated or before, it's fine with me, but it is relevant, sir.
Okay, you're understood, Your Honor. I just, my,
It's limiting. Your case law suggests all photos. We're not going on a fishing expedition. I'm not going to allow that. And if you find that they're pulling up pictures of him sitting on the couch with his dog, I'm gonna have a problem with that, but I think it's very limited in the scope. It is not overly broad as that case that you've pointed to suggests.
Your Honor, the only way, to my understanding of how this works, is that an individual retained by defense counsel would have to personally go through all these.
Well, that's what the forensic reviewer will do. They'll go through and look. I mean, if y'all want to sit together, I don't care.
I will just note for the record as well, we have, if plaintiff wants a different forensic inspector, we're fine with that. We're agreeable to finding a neutral one if so, but.
Great, how about a neutral forensic person that you both choose? You both can be present too if he's there, and then if something is happening that you think should be happening, we're available to him phone.
Okay.
Is that okay?
I think that resolves it, Your Honor.
Great,
Thank you
let's
so
do
much.
that. Thank you. Please place that in the order too. All right, we are on the record on docket 26-21 19CZ. Clinicum Esslingen GmbH.
That sounds exactly right, Your Honor. That's exactly what I would say.
Thank you. Right, versus Ephraim Jacoby. And this is scheduled for 2 o'clock. It is now 2:16. The court and counsel has waited for someone to appear on behalf of defendant, and no one has. No one's in the hallway. And I walk over to check the phone. There are no phone calls in regard to someone being late, injured, in a coma, or otherwise unavailable, making this hearing something that should be set in the future. Therefore, we will proceed. And this is a request for default judgment. It does comport with what's been planned, and the judgment is asking for $30,000, cost in the amount of $243.62, and statutory attorney fees in the amount of $75. That has been provided and notarized as required, and the court has signed the order and further there's actually 2 orders that I signed. There's the default judgment order, and then there's an order that was attached to that. So you basically have 2 orders, but I did note on the one that you provided as separate from the court form that defendant failed to appear, otherwise defend, and the court waited an additional 15 minutes. Technically, it should be 16 minutes. So, and now it is 17 minutes. Is there anything else we need to make a record of, counsel?
No, Your Honor, thank you.
Thank you. We will make sure that everyone gets a copy of this. And then, of course, if they want to appeal this, they'll have time to do that. Otherwise, you could proceed then with the post-judgment matters. This does resolve all claims. The rest goes to the post-judgment.
Thank you. Have a great day. Thank you.
You too. Thank you. Mr. Feigelson, are you all ready to go? Because I can take, I don't know, yours was scheduled at what, 3?
I think we're ready to go. So I think we can just wait on this.
I'm coordinating that right now.
Who are we waiting?
Andrea should be here in about 10 minutes, she said.
We still need to bring Mr. Bella from.
And I've already called down there. They are working on that too. Diane is here, so.
Hey, Brian.
Yeah.
Sarah and I were talking about Montalvo.
Yeah.
Is that the 21st or the 24th, 2018 of August? Next one.
Are you asking a question?
Yes.
Okay, I'll have to go look. I have to go look at the schedule.
Yeah.
Might as well bring it in here. No one else is doing it.
Yeah, that's a good point. 21st.
Good enough for me. We'll be ready to go. Are you here that or is it a new walkway?
Hmm?
Is there gonna be another law clerk on, next month or is it gonna be Friday?
Yes.
Yep, 21st.
First August.
Yes,
Yeah. Montalvo. How long do you think that was gonna last?
probably 2 weeks.
2 weeks. Noted in the book here.
Hey,
Is that the first one up?
Yeah, it's a 23 case.
Oh, yeah,
And
okay.
it's in custody.
I'm sorry.
Oh, okay.
Judge, I'll get with your staff. I think he'll behave, but that's certain.
Well, if that's the case, just maybe know we need the ankle cramp, just maybe know the book. Or
Yeah.
not the ankle cramp, the ankle,
Stun cuff.
Stun cuff. Just put stun cuff question.
You are dying to use that, right?
I am dying to see it. I want to write about it in one of my books.
Fair enough.
And I gotta see it. I've seen the other many times, but I'm dying to see that. And I know that you guys are dying to see me hold an attorney in contempt, so we're seeing which one happens first.
I won't be.
Can I pick the attorney?
I can see that, but I hope it's not me in that case. I'll leave it at that.
I would pick you, there are a couple of.
This bet has been a long time coming since the stun cuff. I'm like, I wanna see that. A couple of the deputies were, we wanna see some attorney held in contempt. I'm like, well, we can manage that.
I'm interested to know what attorney.
I was gonna say, take your time, we'll help you out if you help us out.
I think I know.
Okay, I got the best of both worlds. Can we hold the attorney in contempt and put him in the stun cuff?
Ooh.
Oh, you know?
Okay, so you're thinking a male attorney.
You're right.
Oh, I know who might be going to my mouth shut.
I've got a few civil ones I'd love for you guys to use it on.
So let me ask you this, is anybody up in our jail thing?
Yeah, I brought him up.
Oh, you brought them up, I was gonna say, because if it was empty, I was gonna have you throw my students in lockup.
No, I brought him up.
They're dying to see the lockup, and I think every student, they did this to me when I was a student, so a judge in Detroit. And he said, come here, and he put us all in the lockup, and what he did is he shut the door. And all of us got the chills, because when you hear those, the clang of those doors shut and locked,
It's a one-way lock. You don't have a lock on the inside.
yeah, and it really is, it is something that you don't forget, and I don't know how defendants have this, roundabout, they come in, they come out, they come in, they come out, I don't understand why you would want to ever feel that again. I mean, I didn't think it was good for the 5 minutes you put us in there.
Because, and it's so simple things,
Hi, friends. Hi, Judge. You're muted.
Oh my gosh,
Hi, how are you?
you look like half of you is there. You look great.
Oh, thank you. I went and got some Botox this morning, so.
Oh, well, you need to just share. Can I make that order?
Oh, yeah.
Sadly, I get the Botox for migraines, and it's not put in any fun places that help my body. It just helps my brain not have migraines, but they put it like in my shoulders and my neck and my scalp. It's
Oh,
not fun.
I 100% get it because I am constantly scowling and constantly have a nasty look on my face.
Well, with reason, it's so funny because up in my emails comes, or in my, I was scrolling for something, and up in YouTube or something comes that, the case with that mom that I sent to jail, where you were just, and she did this and she did that, and it was marijuana.
Oh, yes.
So if you go watch, and I'm like, what? And we did this like a month ago. Chris, there's so many hearings. I don't remember all of them. So I'm like, what hearing is this and why is it out there? And so it's got you doing all this stuff and it's just, you know, and it's this funny caption on it. And I'm like, okay, people are watching this.
Oh, goodness. I always have to be careful. Be careful about what I say because you guys know I have that joke right in that foot in the mouth syndrome.
Oh, me too, but none of us say things perfectly, but it's just interesting. It's all interesting, but yes, I think during that one you were frowning. So.
Nope, up here, so you
Okay.
talk into the microphone, thank you.
So we're going early, everybody's here then.
Yep.
Everybody's good to go early,
Yes,
we're not
ma'am.
expecting any, victim witness, anybody, right?
No, correct.
All right, great. And did you say this is gonna be a plea?
It's not gonna be a plea.
Or it's not, okay, so, this is docket 26-2530 FC, People of the State of Michigan versus Raylan Lakota hyphen Keith Bell. Counsel, your appearance for the record.
Good afternoon, Your Honor. Andrea McCray, appearing on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Bell, standing to my right today.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. This was scheduled for 3, but it appears all the parties are ready, and my next hearing is not ready, so we're taking this early. It's 2:38, but I've been advised by both counsel that we're not expecting anyone, and we are free to proceed. Now we are ready to proceed. So, sir, have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And have you had enough time to speak with Mr. Feigelson?
Yes, Your Honor, but
Yes?
I feel like there's lack of communication here between me and him.
Okay, so did you need some time to talk to him now, or what?
I would like to have him off my case.
You want a different lawyer?
Yes, ma'am.
Okay, you think there's a breakdown in the attorney-client relationship?
Yes, ma'am.
All right, where are we in this case?
Yeah, we are set for a plea / pretrial. I know we were in front of the court maybe at the end of May, maybe I might be off on the date for a pretrial where the offer was conveyed. Mr. Bell wished June 24th, excuse me, Your Honor, and an offer was conveyed. He wanted some time to think about that offer. And I met with him yesterday and he's not satisfied with me and he's not happy with the offer.
All right, what is the offer?
Thank you, Your Honor. There are 2 options to the offer. Option 1 is for the defendant to plead guilty to child abuse first degree with a habitual third offense notice. Upon successful plea and sentence, people will dismiss counts 2 through 3. There is a sentence agreement of 12 years of a fixed minimum in the Michigan Department of Corrections. No contact with Lena, Lena, Trayer, Trayer, and King, common spelling, Brooks, Brooks. The sentence is to run concurrent with the Eaton County cases. He has 2 Eaton County cases that he just recently pled guilty on, Your Honor, where he's going to be doing 30 months in the Michigan Department of Corrections. One of those cases can run consecutive because he was on bond when he picked up this case. Option 2, in terms of the plea agreement.
So, let me just stop you there. So one can run consecutive. Is it part of the plea that it would not run consecutive, or is it up to my discretion?
No, as part of the, so at trial, it will be up to your discretion. As part of my plea, I'm giving him credit for time he's doing, and I'm agreeing that they will run concurrent. So it won't get stacked on the 30 months.
Okay, and then did you say a habitual, is there, I know the habituals are filed separately. I was looking to see if it was filed. So is there a habitual third, you said?
He is.
Okay.
And as a reminder, the child abuse first is a life offense anyways.
Okay. All right. And what's the other option?
The second option would be the same as option 1, but no sentence agreement, so that both parties could argue for whatever we wanted. The guidelines under my offer are 81 months to 202 months. So obviously, if he picked the no sentence agreement, I'm guessing they would be asking for 81 months, which is 6.75 years or below that. I would obviously be asking for the high end or even higher than that. It would be, we could argue for whatever we wanted.
I'm sorry, is it 201 or 210?
It's 81 to 202. So 6.75 years up to 16.8 years. Now at trial, right, his guidelines at trial are 108 months to 270 months, which is 9 years on the low end up to 22 and a half years.
And then there's the issue of the consecutive.
Correct.
Okay.
And just putting everyone on notice that at trial, there would be a lot of 404B and other acts about all of the stuff he's done in North Carolina. In addition, I would be asking likely mid-trial for a tampering with evidence based off his jail calls with Lena Trayer from, where is he at right now? Eaton County.
Okay. So are those options that you've heard about and talked about with your attorney?
One of them, yes, ma'am. One of them that I just heard you talk about, yes, ma'am.
And Judge, oh, sorry. Go ahead, sir.
The 80 to 200 months.
Okay.
Oh, and
The only
10
difference,
years.
the only difference is the sentencing discretion. So under one, I would be locked in where you withdraw your plea if I did something different, and under the other, there's no sentencing agreement, so it would be up to me. So, do you understand that? Okay, so on one of them, my understanding is there is the 81 to 202 months, okay? So on one option, if you take that, then there's an agreement to the 12 years. That's kind of midway.
Judge, I thought.
Well, if I could add in something further, Your Honor, is that was the offer on June 24th. The defendant countered with 8 years, and he said he would only take 8 years on June 24th. I said, absolutely not. The lowest I will go down to is 10 years, which is middle of the guidelines. And then he suddenly said he doesn't have discovery. He needs discovery to review that offer. So I said I would leave it open. That's why we have this like special pretrial set for today. It's been about 3 weeks now. And so the offer that was available today, that my understanding is the defendant has already rejected from his counsel, is 10 years. I would agree to a fixed minimum of 10 years on the child abuse first. If he doesn't accept.
Is that option one? I wrote 12 years. Is it 10 years?
Yes, it is. Well, it is 10 years if he takes the deal today.
I got it. Okay. 10 years. Okay. And then the other one, option two, there's no sentencing agreement.
Correct.
Same plea, no sentencing agreement. I determine it. And the possible consecutive if I do it, but it's concurrent on option one.
Correct.
Did you understand all of that?
Concurrent, run together.
So concurrent means all of your sentences run together, Eaton County and my sentence.
Yes, ma'am.
Consecutive means you have to finish Eaton County first before mine kicks in.
I understand.
So do you wish to plead today? Do you want to wait for a new attorney? What is it you want to do? Do you want more time with Mr. Feigelson?
I'd rather have a new attorney, because from the start, I knew I was gonna do 30 months in Eaton County. Some odd reason, I was willing to take a plea, thinking that when they hollered concurrent, I figured, well, maybe he said it something when we first met. He could
This
get it
is,
down.
right, and I'm sorry to interrupt you, but the agreement for today is concurrent.
Yes, ma'am.
Your 10 years that you want and concurrent.
But that's, I don't, I mean, not
You
that.
just said you wanted concurrent, I guess.
Because from my understanding, he had said something other about we could get, you let me work, I could get it down to 2 to 3 years and we could see if we can get it run concurrent. I figured I was already doing 30 months over in Eaton County. I figured, well, maybe I'll get it 30 over here, just go ahead and take it, to keep from her even getting in any trouble.
Who's her?
The child's mother.
Who cares? Deal with yourself. She's gonna, if the case goes, the case goes with whatever her is. I don't know anything about that. You gotta save your own skin here.
Yeah, exactly, yes, ma'am.
So the issue is today, there was never a 3 years or whatever. The issue today is, do you wanna take the 10 years or not?
No, ma'am. No, Your Honor.
Okay, so, and you want a new lawyer?
Yes, yes,
All
Your Honor.
right, so I don't know if it's gonna come from Mr. Freigelson's office, or if it's going to be counsel, we'll get you a new lawyer and set this a month out.
And Judge, I just want to be clear that I am not offering any other plea offers in this case. I'm preparing for trial at this point. I'm not sure what the defendant is thinking because he made admissions to hitting the kid, to popping him too hard. There's a video of him going to the back seat at the lead store where this strangulation occurred. So I wish him the best of luck, but the best deal he's going to get on this case is 10 years, and that's today. After that, nope. And I wish him the best of luck, but you know, I have a great trial record here and I will continue that with this case.
How is the child doing?
He's doing good. He's doing good. He was strangled very badly. And you'll see either at sentencing or at the trial, all the horrific pictures of the petechiae that goes all across his face. And he was 2 years old, all across his face and all across his neck. And as you know, in strangulation cases, we almost never have injuries. They're very rare. And we have insane photos of this poor child.
Okay, sir, I don't know anything about your case except for what I hear. So you can certainly go to a jury trial, at a jury trial. And I don't want to talk you into anything. I just want to make a complete record so you understand and you're fully informed. A jury trial, count one is if the jury finds you guilty, that's up to life. I don't know, it appears your guidelines are 108 to 270 months, but that is only recommended. This court could do worse, it could do consecutive sentencing. Court could also do better, it just depends what I hear and what's going on. And then assault with intent to do great bodily harm, less than murder by strangulation is a felony punishable by 10 years. And that is what I could do on that is 80 to 120 months. So that I don't know what I could do. And then domestic violence, they charge the misdemeanor. That's really negligible. By the time we get to trial, we probably have 365 days. So it's up to you. Do you want to take the plea? If you don't want to take the plea, you don't have to. I don't want you to feel forced, threatened, coerced, any of that. I just want you to make an informed decision. If you don't want your attorney to set this up.
No, I don't want to take it.
Okay. Okay, then we will set this out and we will have a new.
Judge, I would like to set this for trial. I would like to go ahead and set it for trial. We can be the #1 trial on October 23rd, 2026. Because I would like to go ahead and get this tried. We can come back maybe in like 3 weeks or so for his new attorney.
Well, that's what okay, so we have a trial date, October 23rd at 9.
Yes.
We are going to have a final pretrial September 2nd at 11:30.
Judge, I think that the decision of whether Mr. Bell gets another attorney is up to Mr. Cornish. I believe Mr. Cornish has a longstanding policy that he doesn't give out other attorneys, so.
Right,
So
so.
make sure Mr. Bell's aware of that,
Yeah.
your choice would be to go retain somebody or work with me. You're welcome to talk to Mr. Cornish, but that has been his longstanding policy.
There is conflict counsel, which is not from your office.
Correct, so that'd be a decision.
Because he's indigent, can't get his counsel, he's still entitled, so we have conflict counsel, so it won't be with your office, it won't be with public defender's offices. The court, us judges maintain a conflict list for attorneys, and so if their office has a conflict or there's an issue, we will refer you to those other attorneys. Does that make sense to you, sir?
Yes, Your Honor.
Okay, so that's how you wish to proceed?
Yes, Your Honor.
No one forced, threatened, or coerced you, is that correct?
No, Your Honor.
Did anyone promise you anything?
No, Your Honor.
And have I answered all your questions? Do you have any other questions?
No, ma'am. No, Your Honor.
All right, so I'm releasing Mr. Feigelson. We're going to get you a new attorney. If you don't hear from your new attorney in 10 to 14 days, please let me know. Time is of the essence, okay, sir?
How would I be able to let you know?
You just kite me and we will get back with you. Yeah.
They got me on restrictions. I have no access to. Yesterday was the first time I got to talk to my mother in 3 months.
That's on the phone,
There's a reason for that, Judge. That's exactly why we're gonna move for the tampering of evidence charge. There is a very big reason for him having his jail restrictions in place.
So, yes, so we'll just put on the court note that defendant can write a note to judge's office. Or his attorney and the sheriff can review whatever it is you write to us. Okay?
Yes,
So you can't have contact with other people. And that's for everybody's benefit as well as your own, sir. You don't need any more charges. The prosecutor, they have a lot to do, okay? But one of the things they do is monitor phone calls, letters, all of that, because it impacts the case. And so they bring that to me all the time, and that can have result in new charges or privileges being revoked. So be careful what you're doing in there. Just because you're in lockup doesn't mean you can't be charged with new offenses.
Since I was arraigned on this, I haven't spoken.
Okay, well, I don't know what's going on. It's not in front of me.
Did you put him under oath at the beginning of this hearing, Judge?
Yes.
Okay, I'm gonna request a copy of this transcript because that is absolutely not true. So now I'm gonna be looking into perjury.
Sir,
It's fine.
again, you need to be careful about anything you say or write can be used against you. And prosecutors keep records of all of this. This is what they do. People think judges and law enforcement are powerful. It is not us. It is the prosecutor. The prosecutor really has the most powerful office in the nation because they decide what the evidence means and who's going to be charged and not. So anything you say or write or do can be held against you. So be very, very, very careful, okay? And let's get these matters to trial. All right, that's what you want to do. If you want to plead, then you talk to your attorney about it, but it sounds like after this, they're going to limit what their offer will be, or maybe not give you another offer. Do you understand that?
Yes, Your
You
Honor.
still wish to proceed like this?
Yes, Your Honor.
All right, I'll see you September 2nd at 11:30 for final pretrial.
Judge, can we get an order from your office removing us from the case?
There's blank ones right there. Actually, Brian, if you could write that up, Mr. Feigelson's handwriting is hardly legible.
That's fair. True statement. That's fair. Okay. No.
Well, we all know it's fair. I mean, we gotta speak the truth, right? Okay, so,
I think you
that's
did.
why they invented, computers for you,
yeah.
Mr. Feigeleson.
Yes.
All right, anything further?
No, Your Honor.
All right, that's all for the record.
I think you gave it too much credit. Hardly legible, it's not.
No, it is not legible.
Hey, Feigelson, if your office is gonna keep it, like if it's gonna assign it to someone else, then you can just keep the forensic interview. But if you guys are gonna assign it to conflict counsel, you just have to return that forensic interview, okay? Can you just let me know what Cornish says?
I'll talk to him tomorrow about it because he's out until tomorrow. I'm gonna
Okay,
go
for
talk
sure.
to him.
All right, sounds good.
I'll let you know, Andrea.
Okay, thank you, Feigelson. Appreciate it. Bye, Judge. Bye, everybody.
Thank you, nice seeing you.
Nice seeing you.
Nice seeing you as well. I don't need another loser of the case.
You know, yeah, right?
Will not be intended. The defendant is here pro se and the intervener is here.
I'm sorry, what is this motion?
Sorry,
Oh, motion to compel.
motion to intervene.
Or motion, oh, got it. Okay. Okay, this is docket 25-434 CH Carrington Mortgage Services LLC versus Anthony Richardson and Amy Richardson and Johanna Hack and Yvonne Behrens. Counsel, your appearance for the record.
Thank you, Your Honor. Lee Hanson here on behalf of the proposed intervening parties.
Welcome, counsel.
Thank you. Amy Richardson.
And you are representing yourself?
Correct.
Please raise your right hand, because you're not an attorney, correct?
Correct.
Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. You put your hand down. And counsel, your motion.
Thank you, Your Honor. Switch over to the civil side of things. So just by way of backstory on this, some years ago, when I was a young attorney in 2013, I represented an elderly couple named Johannes and Hendrika Matheson, who hired a residential construction company that was at the time operated by Mr. and Mrs. Richardson to perform some improvements to their home. The Mathesons took out a significant amount of money to have this work done. The work didn't get done. We had a dispute over in 55th District Court on that matter that resulted in the entry of a judgment against Mr. and Mrs. Richardson personally, as well as their entity.
Is that in front of me?
No, actually, that was in front of Judge Allen.
Is it? Okay, so long ago, I just, in this case, I don't know why, but it looks familiar to me, but okay.
Unfortunately, those residential construction cases.
Yeah, there's enough of them.
So judgment was entered and the Richardsons ended up filing for bankruptcy protection to try and have the judgment discharged, and we ended up trying that case all the way through the bankruptcy court in front of then Judge Gregg.
Okay.
And the judgments were declared non-dischargeable under the Michigan Builders Trust Fund Act. So this was, I want to say, a couple years after they were originally entered in 2013. So we spent years litigating this, and there are non-dischargeable judgments that my clients have kept current. They assigned all of their rights in those to their daughters, who are my current clients, the proposed intervening parties. Long time's gone by, and the short version of it is Mr. and Mrs. Richardson have evaded paying that judgment that entire time. I've not received a dime on any of those.
Statute of limitations is good because of the continuing actions and litigation, correct?
Correct. Correct. And the judgments have been renewed as required within those 10-year periods. We've also preserved our rights by filing notices of judgment lien against both judgment debtors in Ingham County and actually even pursuing orders for seizure just in the event that we are able to find other assets that are available to satisfy these judgments, which unfortunately have not been able to do. My understanding is that this case that I'm proposing to intervene in arose as a result of a default on a mortgage that on a home that's owned by the parties. So they're looking to foreclose the property, and really all my interest here is if they end up doing that and they go to a foreclosure sale and there are any surplus proceeds, I'd like to see that my clients are able to collect on that.
Yeah.
And also to preserve their rights just in the event that the defendants are able to redeem. The house is foreclosed and then within that redemption period, they're able to come up with funds to redeem, that doesn't get them out from under my client's judgment, and that under the Revised Judicature Act, you have the power to see the judgments of the court carried out, and that we could still have a sale to see that my clients get paid, not just the mortgage company, if there's enough money there to do that.
Okay.
So that's really what we're proposing today. You'll see that my motion was kind of framed in the form of a complaint with numbered paragraphs, and what I'm asking today is that we be permitted to intervene in the case, and that we simply serve a copy of this motion as our pleading, and that there would be a period of time, 21 days, or as the court orders, for the parties to file a response to that and affirmative defenses, if any, and then if not, we're basically just in it as a tag along to the plaintiff.
Okay, so you don't need to then file this, or will this get filed with the registrar against the deed, or no?
I don't know that I follow. We have a judgment lien already.
I did on the property.
Well, the judgment lien is personal to the debtors, right? So any property they own in the county, that would be true.
I just didn't know if there's a sale, you need to provide additional notice, but I guess this would serve as additional notice. Because sometimes those things get tacked on to the deed because of title searches, and because when it goes into whatever foreclosure sale or what have you, then everyone's on notice that this has to be paid first.
I don't believe we have priority over the original mortgage. This would actually be paid second if that happens, is my understanding. Now, that's based on what I've been able to glean from, and I've spoken with Mr. Reed, who represents Carrington on this, so he knows what I'm doing. He spoke to me today to say he has no intent of opposing my motion. So that's really where we are.
Okay, thank you. Ma'am, anything you want me to know?
Yes, Your Honor. I oppose the motion because I believe there's significant unresolved legal issues concerning the judgment liens and the relief being requested. Anthony Richardson has never held title to this property, yet his judgment lien is being asserted against the property.
Well, are you married to him?
We are going through a divorce. It was an
Okay.
18-year abusive marriage.
Okay, and I'm not here to litigate that, but so, ma'am, could you please come up to the podium?
Me?
You.
Oh, sorry, I can.
That's okay. So, ma'am, your home would be marital property, and so that's why he would have a right or entitlement to it. I'm sure it will come out in the Washington divorce, but this case should be also part of the divorce and the monies that you both owe. So I don't know if that's gonna be joint several. I don't know if that's gonna be divided. I don't know what assets you have to divide in a divorce, but that would be interesting, I'm sure, for the creditors to know. But, ma'am, I think what you're arguing to this court are issues that belong to the older cases. I'm not relitigating any of those circumstances. I'm simply looking at the debt.
Right. No, I'm talking about the judgment lien in his name is attached to the title, which is only in my name. And
the title might only be in your name, but it probably says Amy Richardson, a married woman, which means he has rights and entitlement to it. Did you buy it when you were single?
No.
So it says Amy Richardson, a married woman, which means it provides notice to everybody that he's not going to sign off on it unless he doesn't have any interest in it. That would be determined by the family court. And if the debtors come after solely you, because that's solely your property, then that will go to extinguish both of your debt. I would suggest that you talk to do you have a family court lawyer?
No, I don't, Your Honor.
So who's your family court judge?
Your Honor, there's been no divorce actually filed yet. I've been being told that for 3 years.
Okay.
Yes, there has been.
Okay, where's it been filed?
And it wasn't.
Where, talk to me, not her.
Sorry.
Where's it been filed? What county?
It would be the 30th district, I believe, or.
It's the 30th district, so you live in Ingham County, so.
It's
if
the
you
one
file-
downtown
That's
in
this
Mason.
No. Well, I suppose if it's Judge Garcia, maybe he's doing some divorces these days, but I think he's just probating, taking some of our civil.
I didn't think to bring the court document, but it's in
Yeah,
there.
we can look
It
to
is
see if
in
it's
there.
filed. And okay, so.
But I would like the opportunity to keep my house. My husband has basically taken everything from me. And I know the defendant just said something about 3 years. We just became into contact again last year.
Okay.
And I've been in contact with her, and I'm not disputing the obligation.
So how much money is owed, ma'am, do you know?
My part is like 13,000 of judgment lien, maybe 15,000 right now.
Stop right there. Are there two separate judgments?
There are two separate judgments, Your Honor.
Okay, and so here's the deal, ma'am. I don't know what property he has, but if this home is given to you and he gets some other property, they can go after his other property and him. But whether it's 15,000 or whatever is owed, if you get this house in judgment, what they're gonna do is they're gonna come to me and ask that your house be sold so that to satisfy the judgment. So what you need to do is talk to a mortgage lender or some kind of, whoever's gonna give you a loan so that you can pay this off. You need to pay off this debt because they're gonna come after your house otherwise. Okay, so ma'am, your judgment is docket 26-3, and that judgment, I should say divorce action, 26-3311-DO. And it was filed June 30th, 2026, and it is in front of Judge Koenig, and that's downstairs on the second floor. And her office is, I think, at the end of the, let me see. Yeah, her office is either at the end of the hall or, oh, that might be Judge Dunning's, and then I think it's hers. So it's the second one from the end, down on the second floor. So you're in this building, even if you filed it in Mason, they transferred it here.
Gotcha.
Okay,
Okay.
so you know that. So,
I'm simply asking, I mean, I would prefer no intervention, but I'm just asking right now to not allow a forced sale if I do recover the home. I would like to reestablish my life. I'm not excusing the debt, but this marriage was very hard on me, and it's been a slow recovery.
are you working?
And I'm working some, but I'm not quite where I need to be yet. Like I said,
What do you do?
I was self-employed. Right now I'm door dashing, but I'm hoping between these I was just in court with her last week, which she had adjourned it, and then I come here in 2 weeks. I'm going through a divorce, but my goal is still to, recover through this. It's been a mess for me.
I appreciate that, and I think council does too. We see a lot of this, and it takes a strong person to say, I'm gonna recover and I'm gonna overcome. Well, part of that recovering and overcoming is dealing with the past things that have happened. And that's gonna be tough, but it's also going to mean that you gotta pay your debt. Now, if you come to an arrangement with them and pay them $200 a week or whatever it is, and you stay faithful on that, maybe they'll do something. But if they come to me and they say, she's the sole owner of this property, and we're gonna force a sale because she hasn't paid, that's their right to do, and I'll make a determination at that time, but the likelihood, ma'am, of it being sold is there. So you need to talk to some people about getting a loan, whether it's other family members, the bank, I don't know. If you have a bad credit rating, the interest is gonna be astronomical, and maybe you should live in an apartment or something until you're back on your feet. You can have a nice down payment for a house. I really don't know. I don't know if they're open to talking with you or not. I'm very limited in what is here. I am going to grant her intervention. It is appropriate. But if you want to make a deal with them and start paying and don't default on it, maybe they'll agree with that. I really don't know. What's important is that they start getting the money. So I know a lot of people do DoorDash, make a lot of money, but a lot of times it's a second job. There's jobs all over the place where
I have to reestablish myself, and I'm trying to do that while door dashing, while going through courts and all of that. And my health took some time. I had no idea when they say that the body keeps score. It was a rough recovery here, and I'm just finally getting my cognitive abilities back to where I can think clearly. And I, like I said, I know that I have a portion of my debt. But I also want to keep my house. It was hard. He did a lot of wrong things to me, and it's been tough.
well, congratulations for getting out and standing up for yourself.
Thanks.
That's a lot, huge. You
Yeah.
should be proud of yourself. But we have to work this out too.
Yeah, I
So,
agree.
I'm allowing them to intervene. Council, you can prepare an order, and then if you're all here, maybe they're willing to talk with you about you starting some payments, and that might change their mind. I really don't know, but you really need to act in good faith and not ignore them. This is an ancient case. So
It's hard right now when I'm still not, making the money. I keep thinking next month, and I really think I'm close, but right now, I can't offer something because I don't quite have it. But I do believe that, I know if I can recover my home, I know I can make payments.
well,
I know that I have it in me, and now that I have the dead weight gone, my load is a lot lighter. It's just a lot all at once of fires.
okay, well, Ms. Hansman is easily reached. You have her phone number,
I
right?
do, and we've been in touch, and I've reached out, and she's always been able to reach me.
Okay, well, why don't you say a month, so why don't you put it on your calendar that August 15th, you reach out to her and say, hey, how about $100 a month or whatever. I'm sure that whatever you can give to her, they wouldn't turn down. Whether or not they're gonna come back to me or not, I don't know, but how about some faithful payments and then see where they land? Even at $100 a month, 15,000 is gonna take a long, long time to pay. But maybe you can look at some other options, a second job, some family assistance, a GoFundMe. I don't know, people do different things.
I had great credit until he stole my money, so I'm working on getting my credit back. I mean,
Well-
there's just so many moving parts right now that I'm tackling all at once.
Yeah, so you are typical, there's the Lenore Walker cycle of violence. And if you're not familiar with it, look it up. That's you.
Say that again.
Lenore Walker, Lenore, Walker, Walker. Lenore Walker has developed, I think it was in the 80s, the cycle of violence. And that's what you have been in. And if you read about that, you will come to understand how you were victimized and why you stayed there so long. We've heard your healing. I hope you're in therapy.
I am.
Okay. So all of that will make you stronger, and I think you'll feel better too when you start making payments for all of this. And then, have a chat with Ms. Hansman. She can have a chat with her clients, but they're entitled to the money. You, though, have options, maybe, whether it's through another job, selling some things, or through this judgment of divorce where he pays you X amount and you turn it over to them. Because it sounds like he owes you a lot of money. Get your paperwork together for Judge Koenig, because she's gonna have to make a decision what happened.
Right.
So, and if there's domestic violence, he may very well have to pay you spousal support or for your counseling. I don't know your financial situation or any of that, but that can be all on the table for Judge Koenig, and some of that money then can be flipped over for this debt. There are some options. It's not completely bleak, okay? And I know you don't have a lawyer, but you can contact the State Bar of Michigan or legal aid and possibly get some assistance. How old are you?
I am 54.
Okay, I don't know if you qualify for the Elder Law Clinic, but you can certainly try. I don't know what their cutoff is, but there's help available for you. And the idea is, I think you get it, this money has to be paid. We're gonna
I agree to that, I do.
So let's be
I don't-
proactive, yeah.
Yeah,
Let's just be proactive, okay?
yes,
And
yes,
then please let Judge Katie know all this, okay? And
yes.
do you know how to, do you have her current information, how to reach her?
She is accurate when she says we've been speaking. What, obviously, I didn't know about the divorce filing, as that was extremely recently. I'm very interested to know if her soon-to-be ex-husband's been served, because my understanding is he's been hiding and evading service from me and from everyone else for some time. So if he's been able to be served, that would be of interest to me as well.
Has he been served, do you know?
No, actually, I am also filing for exclusive use of home. And I had, my plan is to go tomorrow. It just, apparently they gave me all the copies back, but I wanted to go about finding more info. They did give me a sheet and said, oh, if you can get him to sign this, but I'm still not sure how to get him
So I
served
can't
yet.
give you, well, I can tell you exactly. I can't give you legal advice, but in terms of exclusive use of the home, it's called an ex parte order, and the judge generally, family court judges sign that. I did family law for 20 years. It's an ex parte order, it's one-sided order, and you just ask for that, especially if there's been domestic violence, okay? But you have to get him served, so you need a process server.
Right.
That'll cost you, I don't know, 30 or 60 or 80 bucks, depending on the attempts, but they're very, very good. If he doesn't have a mailing address, and you can also, if they can't serve him, they will follow through and ask the court for alternate service such as tacking. So it can be tacked on your front door, any place he frequents, his parents' houses, his employer. I mean, it just depends on what's going on here. But you need a process server, and there's some exceptional ones in this county.
Well, he is out of state, and I just wanted to clarify that when I went to file for divorce, she had said that the person who could help me with the hearing for the exclusive use of home was not in, and I didn't know she gave me all 3 copies.
Who's
And then
the clerk?
the clerk, when she filed it, and she said, don't send that and don't get a process server until you have that done. And then as I stated, I had court with her last week and court with you today, so I am gonna go tomorrow, but thank you for.
So the ex parte, and that the reason they've done it, I assume, is so that you can serve that ex parte along with the complaint, because generally the complaint and the ex parte orders are filed at the same time. You're not a lawyer, you didn't know that, so you've lost a little bit of time.
Right.
And when you go tomorrow, make sure you get the name of, there's Michael Ramsey, I don't know if he's still doing it, there's a lot of good hunting dogs out there to get them served in state or out of state. So there are different options. So you've got to do that.
I do, I know, yeah.
And if you could keep Ms. Hansman informed, that would be helpful, okay?
Yeah.
You have any other questions?
I do not, but thank you, Your Honor.
I'd like to.
Thank you.
All right, thank you. I'll sign the order.
I do have a proposed order with me, if that's okay.
You may approach, and then ma'am, if you just wait a moment, we're gonna get your copy of that order.
I will say I'm interested in what I was told, because Mr. Richardson filed an answer in this case, but claimed to still be living at the home that Mrs. Richardson is still in, and I know he's not there. And I will tell you from my own efforts, he knows I'm out there, and he's made himself on purpose very difficult to locate. So if, you know, I have told Mrs. Richardson many times if she's able to find him, perhaps that's in her best interest.
Yes, it absolutely is.
And I have explained to her that when he filed, he was still at home and he left in June. So if she noticed the dates on the filing for this, he was still very much home. So I don't know what that, I mean, he's been gone for over a year now.
Are you reaching him through cell phone? Do you talk to him on cell phone at all?
I have limited it to email.
Okay.
And so yes, he does know that I had been filing. I have let him know that he has gotten court papers. What does he want me to do with them? And I'm not getting any response
Do you have
back.
a personal protection order against him?
I never did get one.
Okay.
A part of me is kind of worried to get one.
If I may, Your Honor, I have a question then on that. If we have a valid email address for him, given what's, and I don't think I have to do this because I believe he's appeared in this case, and you know, that is, I can serve him via mail once he's done that, but because we know he's no longer living at the home, would it be possible to have a copy of the intervention order and others served on him via email?
Sure, if he's evading service, at least we give him notice, some record of notice. I don't have a problem with that. And then you can tell me if it bounces back or not. Do you have his, can you tell us his email, man?
I'm sorry.
Can you tell us his email?
Yeah,
Serve him with a
yes.
copy of this? You
Yes.
should not do that because we don't want him coming after you or hiding out so you can't get divorced. It'll just take longer. You can get divorced if he hides out. There's ways to do that, but let's.
Yes, I do have his email.
So what is his email?
It is, Tony M. Richardson.
Is that Tony?
Correct.
M. Richardson?
Yes. M is for Michael.
At
gmail.com.
No special spelling or numbers.
Correct.
Okay.
May I ask you a question?
Yep.
I just wanted to clarify that you did the intervention but not authorize the for sale at this time,
I
correct?
have not authorized the for sale, so
Okay.
gather the money, do what you can do. They want their money, not the property. It's gonna be a lot more expensive, time consuming, and more painful for them to sell your property. And if you can come up with the money, everyone's gonna do the happy dance, including you.
What if I told you that my husband did damage, which I can't sell the property like I should be able to?
Then they're gonna get a reduced amount and you can't sell
So-
it, but you gotta tell Judge Koenig that because then he gets less of the house and he'll be responsible for payment or more debt. She's gonna take care of all that. I wish I could do that. They should have one-stop shopping, so I could handle both, but I can't. So you need to tell Judge Koenig that and bring some evidence. Okay?
I will, believe me.
Your Honor, if I may then, is it possible we could write in here that service upon defendant Anthony Richardson shall be by email at?
Yes. Maybe the original.
I'd also be interested in noticing him for a deposition. So that would be one of the ways, if we know he's receiving service by email, at least I'll have that information.
I don't think he's responded to my emails in 2 months. I'm not sure.
Well, a court order does carry a little bit more weight.
I'm not saying otherwise. I just wanted to clarify that.
It now says service and other court/case pleadings shall be made to defendant Anthony M. Richardson via email at tonymrichardson@gmail.com, since it appears he is evading this court and attorneys of record.
Thank you, Your Honor.
He just has no interest in the property. He said I could have the house, like he was giving me some great thing after the damage that he did.
Take pictures of that.
I have some of the pictures. I do.
The other thing, and that would also be for exclusive use, and you might need a no contact order. The great thing about no contact order does not save lives. But what it does is it puts police on alert that there is a domestic, and so they can be prepared for the worst. So if you dial 911 or put a sign in your home or whatever, if he's there, they
That's-
know.
That's my other concern of doing ex parte versus just filing it, because once he knows he's been exposed, you know, I don't know if his threats to kill himself were true or if he doesn't value his life. So I've been really walking on eggshells
So.
with some of the things.
Okay, you really need to read, Wendell Walker's Cycle of Violence. One of the things that is, we see all the time, and you'll read about, the extended articles that go on, but threatening to commit suicide is a way to control you. You have no control over what he does or does not do. And what he does by threatening suicide is hold you hostage to those threats and continues to control your actions. You need to do the actions that protect yourself, your family, your property, and forget about whatever he does. He's the only one responsible for his
No,
life.
I'm saying I don't know if
If he'll commit
if-
suicide, that's not.
if he means it, then it could mean that he doesn't value his life. He's not gonna care what he does to you. Is what I'm trying to say. Does that make sense? So I'm
Yes,
kind of
because-
walking on eggshells of.
Because what we see every day is people killing themselves, their spouses and children. I
Right.
get that.
So
but
that's where I'm at
also-
with some of that, of what to expose when it's.
Yeah, you know, we get into a sticky wicket, but if you feel sort of held hostage by those statements, it's part of control as well. I don't know your full situation. Talk to your therapist about all this.
Right.
But you need to do what protects you.
That's what I'm trying
And
to
a personal
do.
protection order does provide that notice to law enforcement, it does provide notice he can't be near you. You make sure your friends, family, everybody, neighbors know, they see his car, they see him, they dial 911, there's a PPO. So, it would help, and we appreciate the information you've given in this extra time, and council got some extra information, so, just keep everybody informed, and that's really your best bet here, okay?
Thank you.
Thank you.
Thank you,
Thank you,
Donna.
council, thanks for your patience. Any additional matters?